So I want to begin by congratulating Senator Éireann and the Civil Engagement Group for bringing forward this bill. It certainly demonstrates a level of thoughtfulness and an intervention that is both honourable in itself and also honouring of the victims and survivors of sexual abuse who have been subjected to NDAs shamefully. It's a most appalling use of an NDA, and it further perpetuates the abuse in a most egregious manner in my view. I apologise that I did miss it, clashed with an appointment, so I missed that. But I didn't mean any disrespect in not being there. I think, and I suppose I stand here and as you spoke, I thought to myself, gosh, a lot of my speech I think is explaining that I have never done this as a legal profession. So I apologise for what I'm going to say because it does sound like I'm distancing. But I think it's important in the context of this to put on the record that NDAs do have a place. They do have a very legitimate role, and you know that the normal place where they should happen is in the context of maybe businesses in exploratory talks with each other, where they need to exchange information, and nobody should benefit from the commercial advantage of that information exchanged. So in that context, that is where an NDA is perfectly legitimate. You know, in the context of normal severance packages, there can be a non-disclosure element, but that's generally couched in the terms of confidentiality, non-disparagement. You know, so just because a confidential agreement is reached by a soon-to-be former employee, that doesn't mean that it's necessarily sinister or that anything sinister is going on or being covered up. In my own experience, in the ones that I've written, it usually occurs where a relationship has broken down to such an extent that it cannot be redeemed, and therefore the most honourable way forward is a severance package of some sort, and both parties agree, and maybe both parties could litigate successfully or unsuccessfully, but the risks of litigating are not to anybody's benefit, and so they serve both the employee and the employer. But for such an agreement to have a legal force, there have to be the elements of being entered into freely by both parts. That, you know, there have been instances in my own experience where I've held up agreements, even though there's a rush to sign, get it over with, to make people sit back, have that, you know, few days of cooling off and thinking, is this really what I want to do? Do I really not want to proceed? So the people aren't signing out of fear and panic, but that they get advice from the signatories, and that especially when the employee is always the more vulnerable party, so they must have the benefit of legal advice, and that the agreement has to have in it exemptions for disclosure. So I have to say the sheer extent of it, as expressed, I have found shocking, and I have not come across it. I confess I haven't. So I mean, it's normal for severance agreements to have non-disparagement clauses for an obligation of secrecy, even to the extent of the existence of the agreement in some instances, because it may set a precedent or it may have other consequences. But it is never envisaged that it should have been that in an unforeseen cause of litigation that it would be used or prevent someone from going to the Gardaí. I mean, that's an appalling abuse, and it's appalling twisting of what are legitimate business practices. You know, so in a context of the employment environment, you know, there are a couple of things that need to be considered. First of all, the use of an NDA where there has been sexual harassment or discrimination is manifestly inappropriate, and so this bill is perfect for that. You know, so let's be clear on what the obligations of employers are. They are that they must create a safe place for people to work in, that they have obligations to have policies and procedures that are effective in place. That the very first thing that should happen is that the complainant is encouraged to go to the Gardaí, and alongside of that the employment relationship has to be dealt with, and that there is a statutory instrument, 146 of 2000, that sets out how a grievance is to be dealt with. But there's nothing to preclude an employee that is found or a perpetrator employee that is found on the balance of probabilities to be guilty of sexual abuse in a context, they should be sacked. It is a gross misconduct. So there are things like that that employers just should do. There should be no place in law for these. You know, and what I think is horrific about this is that it is facilitating putting the blame in the wrong places. It's the employer absorbing a blame of association, of facilitation, which in itself is wrong. If you have the misfortune to employ someone who is a perpetrator of a sexual offence, that is horribly unfortunate, but it's most unfortunate for the person who is the victim of that perpetrator. And so by having an NDA, you are somehow saying the victim is to blame, the employer is to blame, the perpetrator is to blame. That should be the only message. And I think that's where this bill very clearly makes that and apportions the responsibility and the blame to the one person by exempting the use of these, and it should be a criminal offence for anybody. It is shameful that any lawyer would consider this and would facilitate this, and I am appalled by anyone who so does. So I think we should write to the Law Society and the Bar Council to say this needs to be in a code of conduct for this not to be in place. But well done, and thank you very much.